The Financial Survival Network, helping you survive and thrive in the new economy. Go to CarrieLutz.com and sign up for 30 free micro trainings on financial survival.
1490 WGCH, this is Carrie Lutz. You're listening to the Financial Survival Network, and it's time for another Triple Lutz Report. If you remember, a couple of weeks ago, I did a Triple Lutz Report concerning the reauthorization of the Department of Defense appropriation, Senate Bill 1867. And there was a big uproar, big outcry over this because people felt that anybody could be simply defined as a terrorist and therefore subject to military custody. And I was concerned about it. It seemed yet another step on the way to the police state that we all know we're heading towards. But I have to admit, I didn't read the full law. For that, I apologize, because in law school, they always said, when in doubt, read the law. If still in doubt, read the law again. And if you're still in doubt after that, call a lawyer or a law professor. Let me just read the law here to you. I think it's pretty clear. I think we might be talking about a tempest in a teapot here. Section 1031, it's the main subtitle is Subtitle D, Detainee Matters. Section 1031, Affirmation of Authority of the Armed Forces of the United States to detain covered, emphasis added, persons pursuant to the authorization for use of military force. And it starts off Section A. In general, Congress affirms that the authority of the President to use all necessary and appropriate force pursuant to the authorization for use of military force, Public Law 107-40, includes the authority for armed forces of the United States to detain covered persons as defined in subsection B, pending disposition under the law of war. Now we have Section B, covered persons. A covered persons under this section is any person as followed. 1. A person who planned, authorized, committed, or aided the terrorist attacks that occurred on September 11th, 2001, or harbored those responsible for those attacks. Section 2. A person who was a part of or substantially supported Al-Qaeda, the Taliban, or associated forces that are engaged in hostilities against the United States or its coalition partners, including any person who has committed a belligerent act or has directly supported such hostilities in aid of such enemy forces. Goes on, and disposition under the law of war, the disposition of a person under the law of war as described in subsection A may include the following. 1. Detention under the law of war without trial until the end of the hostilities authorized by the authorization for use of military force. 2. Trial under Chapter 47A of Title 10 United States Code as amended by the Military Commissions Act of 2009, blah, blah, blah. Transfer for trial by an alternative court or competent tribunal having lawful jurisdiction. It goes on. Construction. Here's a kind of important one. Nothing in this section is intended to limit or expand the authority of the President or the scope of the authorization for use of military force. And then there's the Secretary of Defense has to regularly brief Congress regarding the application of the authority and all that good stuff. Now we get to Section 1032, custody pending disposition under law of war. 1. In general, except as provided in paragraph 4, understand these are statutes written by congressional aides trying to hide everything that they possibly can, but sometimes even they can't help making it somewhat clear. The armed forces of the United States shall hold a person described in paragraph 2 who is captured in the course of hostilities authorized by the Authorization for Use of Military Force, Public Law 107-40, in military custody pending disposition. Okay, so we get to Section 2 of 1032. It's actually paragraph A, Section 2 of 1032. Again, we're dealing with statutes. They're not really supposed to be clear to the average person. They're supposed to be clear to attorneys, but I know lots of attorneys that can get into shouting matches trying to construct or construe a statute that should be the most obvious thing in the world, and yet to the people who are debating it, nobody can figure it out. And just try doing your taxes one day if you don't believe me. So we get to Section 2, covered persons. The requirement in paragraph 1 shall apply to any person whose detention is authorized under Section 1031 who is determined A, to be a member of or part of Al-Qaeda or an associated force that acts in coordination with or pursuant to the direction of Al-Qaeda, and B, to have participated in the course of planning or carrying out an attack or attempted attack against the United States or its coalition partners. So the important word here is and. So one, you have to be a member or part of Al-Qaeda or associated force. And I don't think Free Republic is part of that associated force that acts in coordination with or pursuant to the direction of Al-Qaeda. All right. And then you had to have participated in planning or carrying out an attack against the U.S. or coalition forces. So we get to 3, disposition under the law of war. For purposes of this subsection, the disposition of a person under the law of war has the meaning given in Section 1031C, except that no transfer otherwise described in paragraph 4 of that section shall be made unless consistent with the requirements of Section 1033. This is where we get a little crazy here. Now we get to number 4. This one is a little amorphous. Waiver for national security. The Secretary of Defense may, in consultation with the Secretary of State and the direction of national intelligence, waive the requirements of paragraph 1 if the Secretary submits to Congress a certification in writing that such a waiver is in the national security interest. So what was Section 1? It was basically someone who was, in general, except as provided in paragraph 4, the armed forces of the United States shall hold a person described in paragraph 2. So it appears, I'm not sure if the waiver, if they can waive the requirement that the person be in Al-Qaeda. It doesn't appear to me that it can, but hey, look, this is the government, and you have creeping regulation, you have governmental creep, where laws that are passed are used for wholly different purposes down the road. So it's something to consider about. And then here's the part that's got everyone freaked out. United States citizens. The requirement to detain a person in military custody under this section does not extend to citizens of the United States, which seems to imply that it's optional, that if there's a U.S. citizen involved, that person, at the option of the military, can be taken into custody. But it seems like they would have to have done something with Al-Qaeda and something involved in hostilities against the military, unless there's this waiver provision. Now, do you foresee the day when the Secretary of Defense, the Secretary of State, and the Director of National Intelligence start waiving the requirements of paragraph 1? I'm not sure about that. It's possible, and it might give them some wiggle room to do it. But on its face, while this isn't the clearest statute, it doesn't appear to be an immediate threat to the public, to people who disagree with the government. Now, to say that the Bill of Rights is still intact and safe is putting it a little bit too far. The fact is, the Supreme Court has ruled that U.S. citizens are entitled to habeas corpus They're entitled to due process of law. You can't say for certain what the court's capable of. That's one of the big problems we have and why the country's become ungovernable, because the Supreme Court can pretty much do what they see fit, and the federal judiciary to a large extent as well. I'll never forget, I was in court on a case in federal court, and understand a federal court judge has lifetime tenure. There's a couple of lawyers debating something, I don't even remember. The case was boring, I wasn't paying attention, but one of the attorneys, a younger guy, says to the judge, "Your Honor, the law in this situation is blah, blah, blah." And the judge takes off his glasses and he scowls at this attorney and he says, "Young man, in my courtroom, I am the law." And that's something you need to remember, because it doesn't appear on its face that this thing is blanket approval to engage in mass arrests of people who are deemed to be threats to the United States without there being the military component. One other thing I want to cover, because we deal with this thing called 107-40. That was a joint resolution of Congress. It was authorizing the use of force by the United States Armed Forces against those responsible for the recent attacks launched against the United States. Right? This was passed September 18th of 2011. So there's another thing where you have to interpret a statute based upon the law that it's referring to. And effectively, what this statute does, what it seems to me, its main intent, unless there's a stealthier intent that I'm just missing, its main intent is to allow the military to take enemy combatants and ship them off to Gitmo or wherever they deem fit. It could be on a ship in the middle of the Pacific. I don't know. They've got all these secret prisons. That's a little alarming in itself. But there seems to be a clear limitation on S-1867. So while I am concerned about it, and I see the potential of a waiver being issued, I think the waiver part by the Secretary of Defense has to be interpreted within the confines of the resolution authorizing force in, and that's 107 Public Law 40. Okay, it's got to be having to do with the wars in the Middle East, with 9/11 and terrorist attacks directly related to. And we're talking about Al-Qaeda, and we're talking about Al-Qaeda related forces. Oh, and finally, let me just read Section 2 of the Authorization for Use of United States Armed Forces. A, President. In general, that the President is authorized to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11th of 2001, or harbored such organizations or persons in order to prevent any future acts of international terrorism against the United States by such nations, organizations, or persons. And I think that pretty much clarifies it. So perhaps a little bit of overreaction, but look at the times we're living in now. The economy's collapsing. The Federal Reserve is bailing out the world. We see crony capitalism is rampant. So it's not unreasonable for people to see this, read the headlines, myself included, I was guilty, and say, oh my God, it's a dagger in the heart of freedom. And it might well turn out to be that way. But from the face of the statute, in my legal opinion, for lack of a better term, and I'm not giving you legal advice, and don't try to say that I am, I'm just basically interpreting a statute, expressing my opinion. In any event, it doesn't look to me like it's as sweeping and as far-reaching as all the pundits, myself included, initially thought. This has been another Triple Lutz Report. Kerry Lutz, signing off.